One little, two little, three little Indians, four little, five little, six little Indians, seven little, eight little, nine little Indians, 10 little Indian boys. One little, two little, three little Indians, four little, five little, six little Indians, seven little, eight little, nine little Indians, 10 little Indian girls. While we have come a long way with human rights, we still have a long way to go. According to the U.S. Department of Justice, nearly half of all Native American women have been either raped, beaten, or stalked by an intimate partner. And on some reservations, women are murdered at a rate 10 times more than the national average. Um, According to IndianLaw.org, 1 in 3 Native women will be raped in their lifetime, and 3 in 5 will be physically assaulted. 86% of these will be committed by a non-Native individual. The significance of that is when a Native American woman is assaulted on their reservation by a non-Native, nothing can be done to that non-Native person, because federal law states that Natives living on their land are unable to prosecute non-residents for crimes committed on their land. So if things were different, there would be less violent crimes committed towards our women on reservations. A significant portion of residents on reservations are non-Native Americans, largely because as a result of the U.S. government's sale of tribal lands to white people. Relying on federal or state authorities often means having to travel hundreds of kilometers or miles to the nearest forensic examiner or prosecutor, which is federal prosecution of crimes on tribal land is very rare, because not a lot of federal agents or federal government is on tribal land. Between 2005 and 2009, 67% of sexual abuse cases sent to the federal government for prosecution were declined. The OVC.gov and Department of Justice states that in the United States Supreme Court, U.S. Supreme Court, United States versus McBratney in 1882, held that some states were exclusive jurisdictions over crimes in Indian country involving only non-Indians. The U.S. Supreme Court ruled in Oliphant versus Suquamish Indian tribe in 1978 that tribal courts do not have criminal jurisdiction over non-Indian offenders. If the victim is Indian, the federal government has exclusive jurisdiction pursuant to the General Crimes Act. If the victim is non-Indian, the state really has no jurisdiction at all. The state has exclusive jurisdiction over that, but nothing else. So, how is it that this is any different for any other any other woman in America? For any other American woman, she can pick up a phone and call 911 if she was to be assaulted, raped, stalked. If anything, any type of offense is against them, they're able to pick up a phone and dial 911. They can also travel to their local police department and things can be handled for them. For a Native American on a reservation, she has to wait on the federal government. According to NativeAmericanAbuse.com, civil lawsuits are often the remedy available to sexual abuse victims to expose their attacker and to get help. Some Native women have to wait hours and days before federal help arrives. So, if the laws were a little bit different for our Native women, we wouldn't have to wait days to speak with someone about their attack. Their attackers could be prosecuted and situation could be taken care of. If they're not able to talk to someone within a few days, their attacker is able to leave off the reservation, and then there's nothing that they are able to do about it. They won't even be able to find them. In 2013, President Obama signed a reauthorized version of the Violence Against Women Act. And then this is for new prosecution of Native American women. It extends tribal jurisdiction for Native American women over non-Native Americans who commit crimes of domestic violence or sexual assault against a Native American spouse or partner. However, this jurisdiction is very narrow. The tribes continue to have very limited sentencing authority up to 3 years, which in some cases means They're still sent to federal or state authorities for prosecution. However, they could get up to 3 years for it. Some crimes, such as murder, are lifetime sentences, but on tribal land, the max you could serve is 3 years. Doesn't seem fair treatment. It seems like some people go onto these tribal lands just to hunt Native women and know that nothing will happen to them if they're caught. The new law signed only helps those that are in marital relationships. It doesn't particularly help those that have a boyfriend or a girlfriend, or like for non-native living on the tribal grounds. We all have important women in our lives: mothers, daughters, aunts, sisters, cousins. And at what point do we stop and ask ourselves, when does one life become less important than another? So let's try to practice justice for all. I'm Native and I don't want to be a statistic.